Hello, my name is Israel Black, and I'm a lecturer in health law at the UCL Faculty of Laws. On behalf of the faculty, I'd like to extend the warmest of welcomes to participants joining this webinar on the recently launched United Nations Environment Programme report on regulating air quality, the first global assessment of air pollution legislation. In the first hour, we have 4 distinguished speakers who I'll introduce as they come to speak. We then have 30 minutes for Q&A. Without further ado, it's my pleasure to introduce our first speaker, Professor Patricia Kameri-Mbote from the United Nations Environment Programme, who is going to introduce and provide some background to the project. Patricia Kameri-Mbote is Director of the Law Division of the United Nations Environment Programme. Previously, Professor Kameri-Mbote was Founding Research Director of the International Environmental Law Research Centre, where she was Programme Director for Africa. She is a member of the Senior Council Bar in Kenya and has been a Professor of Law at the School of Law of the University of Nairobi. Patricia, over to you. Thank you very much.
Thank you very much, Dr. Black. Distinguished ladies and gentlemen, allow me to welcome you to this webinar, which will discuss, as we have heard, UNEP's recently launched report titled Regulating Air Quality, the first global assessment of air pollution legislation. Addressing air pollution remains a crucial element for implementing the 2030 Agenda for Sustainable Development and achieving the Sustainable Development Goals. Indeed, air pollution is the greatest environmental threat to public health globally and accounts for an estimated 7 million premature deaths every year, which is more than 5 times the number of people who die in road traffic collisions. About 4 million people died in 2019 from exposure to fine particulate outdoor air pollution, with the highest death rates occurring in Asia and Eastern Europe. The impact of poor air quality on global health is estimated at $5.7 trillion, which translates to 4.8% of the world's GDP. It also has negative consequences for the economy, productivity, and tourism. It affects the biodiversity loss, causes acidification of soil and lake ecosystems, and reduces forest and crop yields, threatening food security as the global population nears 10 billion. Distinguished participants, this grim picture is what has triggered the international community and member states to action. For instance, just last week, on Friday, the 8th of October, the Human Rights Council adopted the resolution that for the first time in history recognizes the human right to a clean, healthy, and sustainable environment. This is a watershed moment for international environmental law, environmental justice, and for UNEP. While 80% of member states already recognize the right at the national level, this resolution elevates the right to the international level and formally places the right alongside other universal human rights recognized under international law. We expect that this resolution will serve as a catalyst to help the world to address the triple planetary crisis, which includes air pollution. The resolution can embolden and support governments, legislators, courts, and citizen groups around the world to take further actions to implement their right to a safe and healthy environment. The United Nations Environment Assembly has consistently addressed the challenge posed by air pollution crisis since 2014. At its first session in 2014, the United Nations Environment Assembly called on member states to act across sectors to reduce all forms of air pollution. This call was reiterated at the Assembly's third session in 2017, which urged member states to set ambitious ambient air quality standards, considering the guidelines from the World Health Organization. In response to this call by the United Nations Environment Assembly, UNEP developed an air quality program with a view to offering an integrated menu of services to governments at different levels. The program seeks to ensure that by 2030, most of the world's populations live in areas where WHO air quality guidelines and WHO interim targets are attained. According to information obtained through UNEP's air quality program, many countries lack clarity on whether air quality standards are legally binding. In addition, it is not clear how compliance and enforcement with these standards are monitored. However, efforts to attain the WHO guidelines and interim targets and to significantly lower the danger posed by air pollution to human health cannot succeed without legal and institutional frameworks. A report produced by UNEP in 2016 identified air quality laws and regulations as a key policy action to significantly improve air quality. It is against this backdrop that UNEP conducted a global assessment of air pollution legislation. The assessment was launched in September 2021 and underscores the significance of robust air quality governance in achieving air quality standards and public health goals. Further, the assessment is the start of efforts to assist member states in implementing pollution reduction measures in their own countries, grounded in science-based, integrated, and coherent regulatory frameworks and policies. It will assist countries in strengthening air quality governance, while at the same time providing a resource for countries wishing to effectively address air pollution and contribute to the achievement of the Sustainable Development Goals. We sincerely appreciate the efforts of Professor Eloise Scotford and Professor Delphine Misonne, who played a leading role in researching and drafting the final report. We would welcome your support in disseminating the assessment to all relevant stakeholders within and outside your networks. And in closing, permit me to highlight the following key points: that as we emerge from the COVID-19 pandemic, governments must prioritize policies that lay the foundations for a green, inclusive recovery, which will not be possible without tackling air pollution. This will entail countries working together on sustainable transport, renewable energy production and use, and waste management. Businesses must also be innovative, and we must all reduce our carbon footprints. This will only be possible if we develop strong air quality governance frameworks. With the assessment of air pollution legislation, UNEP as the global authority on the environment is now well placed to provide effective advisory and technical support to countries and the international community to establish appropriate air quality governance frameworks. To this end, we will collaborate with relevant partners and stakeholders to support countries to strengthen, develop, or implement appropriate legal instruments and frameworks and build related capacity to prevent, reduce, and control air pollution. Going forward, we will develop and disseminate guidance material for countries on developing, strengthening, and implementing legal frameworks to prevent, reduce, and control air pollution. Secondly, we will support countries in the review and development of adequate and effective subnational or national air quality legislation. Thirdly, we will support enhanced capacity building for all stakeholders, including judges, prosecutors, and other enforcement officials for increased effectiveness of air quality legislation. Fourthly, we will engage countries within the framework of triangular and South-to-South cooperation to develop a practical guide on tackling air pollution. I thank you and wish you fruitful deliberations.
Thank you so much, Professor Kamari Mbote. Our next two speakers are co-authors of the Regulating Air Quality report, and they will speak to its key findings. So first we have my colleague, Professor Eloise Scotford of UCL Laws, who is going to speak on the subject of regulating air quality, assessing national air quality legislation. Eloise Scotford is Professor of Environmental Law in the Faculty of Laws and Centre for Law and Environment, University College London. Professor Scotford is a leading scholar on the legal treatment of environmental principles and is co-author of the UNEP report regulating air quality that we are here to discuss today. Eloise, over to you. Thanks very much.
Thanks very much, Isra, and thank you very much, Patricia, for that wonderful background from UNEP. I'm going to share some slides. While I'm doing that, I just wanted to acknowledge a couple of people that are in the audience, and I'm sorry we can't see you all, but in addition to the wonderful team at UNEP that Delphine and I worked with, we had brilliant assistance from two research assistants in particular who were LLM students at UCL at the time, Flora McCarthy and Sean Seng. And we needed a research team because to figure out what the law was in 195 countries plus the European Union was quite a research endeavour. And I am delighted that they're joining us today as well, even if we can't see them. So let me share my screen. Great. I should also say that we worked very closely with Alan, who you Meso at UNEP, who Isra will introduce later, and another colleague, Maria Sangriat, who is currently being dragged off to the COP. And we had excellent support from national focal points in helping us understand the law in some countries where we needed extra support. So I am going to run through the scope of the report and about half of the headline findings, and then Delphine will look at some of the other ones, but we still won't be getting through everything today that's covered in the report. So I do encourage, if you're interested in the study and in the report, there's a link there, there's a link on the event page, you can read it at your leisure. There's only so much we'll be able to cover today, but certainly we can discuss some things in Q&A as well. So the scope of the study, as Patricia mentioned, the background to the study is quite grim. There's a question that UNEP had around the legal bindingness of air quality standards, and that's really what our report was investigating in legal regimes across the world. We focused our report on ambient air quality standards, and I just want to explain a little bit what I mean by those. First of all, what I mean by air quality standards. Now, air quality standards in law are a very demanding type of regulation. They require a final result or outcome, a certain level of air quality to be achieved, rather than, for example, establishing standards of behaviour that individual polluters need to comply with, which is the more standard fodder of environmental regulation. So we're really looking at the standards that set the collective outcome that we'd like to see. And they map onto the WHO air quality guidelines that set concentration-based standards as the health-based standard for what is good and acceptable air quality. And we're looking at how those standards might exist in law and might be binding and enforced in law. In principle and by design, they do ensure overall that levels of air pollution are kept within acceptable limits. But as you'll see when we get through the findings, the legal detail is much more complicated than that. And air quality standards don't perfectly deliver the kinds of environmental outcomes they appear to represent in all legal systems. In addition, we focused on ambient air quality standards, and ambient refers to the outdoor air. We did this because most air quality standards globally are ambient. The ones that you find in legal systems are ambient air quality standards. So that's where the law, kind of the preponderance of the law is. But it should be kept in mind that air quality standards can be set for indoor air, and increasingly there are calls to develop that part of regulating air quality better, particularly because of the high levels of exposure that people have to indoor air. And I will talk a little bit about that at the end of my presentation. We had a very clear focus on law and legislative structures in our study and how these make air quality standards binding within states. And to try and understand what air quality law around air quality standards might look like, Delphine and I quite quickly realized that there were quite a lot of different parts of law that are part of the picture of instituting and embedding air quality standards within a national legal system. And so we developed for the study a kind of a model. It's not a model in the sense of a perfect law, but it's more of a map of the laws that relate to air quality standards and their entrenchment within law and administrative structures. So this picture, this is taken from the report, figure 1, we spent a lot of time talking about figure 1 in this study. And it shows how air quality standards, which are sitting in the middle of this, relate to a whole range of laws and legal requirements that embed them within national administrative and legal processes. So this is really kind of a map of what air quality law is and how it relates to ambient air quality standards. So you can see the green bits at the top of this model are what we really focused our study on. So first of all, whether air quality standards existed within legal structures at all, and then whether there was any institutional responsibility for achieving those standards within law, whether there were legal requirements for monitoring the air to see whether those air quality standards were met, whether there were legal requirements for some form of accountability, for planning and for sanctions if air quality standards were not achieved. And then we looked whether there were legal provisions or structures for public participation and rights in relation to air quality governance. And that in a sense was a map for the things we looked at. This is not to say that we think all of these things have to be in every national legal system. They're not, and that these things will deliver compliance with air quality standards. They don't necessarily. There's a lot more that goes on in the policy and economic and social space to make air quality standards achieved. But that this at least isn't a legal architecture that we were looking at. The bottom half of this is other aspects of law that relate to air quality standards, which were not within the scope of the study so much, a little bit, but there we looked at constitutional guarantees that might shape air quality standards. We looked at whether there might be high level air quality objectives informing those standards. We did look at those components in orange. We looked also at grey at whether there were review mechanisms, which is very important for air quality standards, which tend to evolve with both new knowledge, scientific knowledge, which Professor Lewis will talk to us about, but also with political change and the appetite to regulate air quality in different countries. In black, we didn't look at this so much, but this is often where you see the treatment and the analysis of air quality law and policy existing, which is in sectoral laws that support the achievement of air quality standards, whether it's regulating vehicles, industry, and so on. And there's lots of law there, which you could say is also air quality law, but it's part of the package of regulation that will can be brought to bear to achieve air quality standards. So our findings, the big picture, overall a very heterogeneous approach to air quality law around the world. Perhaps not surprising, a range of legal cultures, a range of air quality challenges in different countries. But it's more than that, the heterogeneity, which both Delphine and I will speak about. There is a risk in the way that the technical standards are drafted in law of masking weak ambition and actually legalizing unclean air. And we could see ways in which the lack of ability to compare the way standards are included in law created those kinds of risks. We saw that air quality law looks quite different in different systems of government, and that multi-level governance had quite a big role to play in the design of air quality laws in some countries. We saw that much air quality governance is very technocratic, and this is a bit of a relic of history. It's partly because it's a very scientifically complex area of regulation, but it can mean that these regimes of air quality law are not very accessible to the public, and it can mean that they are they don't necessarily have public health objectives clearly driving them. Many countries are in a process of developing or reviewing air quality law. That was certainly something we found, and we found that there's particularly big challenges around developing governance regimes for indoor air quality, which I'll come back to, and transboundary air pollution that Delphine will speak about. So a headline kind of figure of where we started, I think essentially the inquiry about looking into legal systems was, were air quality standards, ambient air quality standards, which is what AAQS stands for, were they actually contained within some kind of legal instrument? Now, in 63% of the countries we looked at, the answer was yes. That leaves a lot where the answer was no still, but a healthy number. And by legislative instruments, we include primary and secondary legislation, and also policy and guidance that was developed or empowered under a legislative framework. So in some way legislatively created or directed. There were some trends in the countries that have legislated for air quality standards. Sometimes it was a public international law architecture. So we see that in the UN Economic Commission for Europe and EU legal regions have a very high incidence of legislative ambient air quality standards reflecting the regional convention and EU directive in that space. Civil law countries had a very high incidence of these, states with federal constitutional structures, and perhaps unsurprisingly, states with constitutional guarantees that relate or might relate to clean air. The countries that had no legislative ambient air quality standards, there were a range of reasons for this. Sometimes they had no standards at all, and sometimes they had standards in policy and guidance only, so not linking to a wider legal or architecture. The range of reasons why there were no standards are there was no air quality problem in the country. There's not that many countries in the world that have that status, but some do. They have very clean air. To the fact that many countries were in the process of developing laws. Some have powers to introduce standards that have not yet been exercised. In terms of how, and this is quite important, seems quite dry, but it is quite important for oversight of how ambient air quality standards are produced in law. Most of them are introduced by secondary legislation. And this makes sense because of the technical nature of lots of these standards, but it means that there is less scope for public participation and oversight and transparency of the process, and that often the processes for setting air quality standards in legislation are driven by technical expertise, standardization bodies, and so on, and less involvement, as I say, or less inclusive, transparent, accountable. And as we care more and more about, as Patricia has outlined, about having robust air quality standards around the world, that kind of lack of legal transparency is an issue. Now, this slide, I will slow down and kind of walk you through it a little bit, because this is all about the ambition of the standards that exist in law. And it shows that once you start looking into the detail, the picture gets a bit more complicated. And this is because air quality standards are set for different pollutants, and we focus in the report on the pollutants for which there are air quality guideline values in the 2005 WHO guidelines. And that for different pollutants, there's different levels of, or there's different pictures on how they were introduced in law. In particular, we see, if you look at the green bar, that's where there is no legal standard for the pollutants at the bottom. So there's PM10, ozone, nitrogen dioxide, sulfur dioxide, with different means, which are different standards, different averaging means. So this is averaging period. So this is shows you that for different pollutants, you may or may not have a standard in a country. And the orange bar shows that you might have a standard, but it doesn't yet meet the WHO guideline values. Now, this graph is actually out of date because we have for 3 weeks an updated version of the WHO air quality guidelines, which are more stringent. And that means that the orange bars, which are, there might be standards, but they don't meet WHO guideline values, will only be bigger in light of the fact that the WHO standards have gotten more stringent very recently. So the black bits of each of the bar are where there are legal standards and they actually reflect WHO guideline levels. Now, there are different reasons for non-alignment. Positive reasons are that countries are kind of intending to increase air quality standards over time, and the WHO admits that's a sensible kind of way of introducing air quality standards, is to have focus on interim targets and then get to more ambitious standards over time. But the negative reasons are that countries want to preserve highly polluting industries, or they have difficulty making complex choices. Now, there is a bit of a caveat around the accuracy of thinking about alignment of these standards with WHO values, because the legal design of these standards is a matter of precise legislative drafting. And there are all sorts of small things, allowance of exceedances, geographical coverage, the time frame for compliance, that can make a standard look like it's meeting a guideline, but actually there are lots of derogations. And so they disguise their level of ambition a little bit. Which is difficult and makes them difficult to compare across different countries. I'm highlighting here PM 2.5 specifically. It's a very hot topic in many countries, including the country I'm in, the United Kingdom, politically at the moment, to introduce stronger standards for PM 2.5, we found that 62% of countries at the moment do have a standard for PM2.5, but very few comply with the WHO guideline, and that's the 2005 one, which has just gotten more stringent, as I say. Now, this question, this slide shows our findings in relation to legal obligations on the state. And this is part of the story of the enforceability of standards, but a really important part, because air quality problems are collective action problems, and so the state performs a really important coordinating function in achieving these standards. Now, globally, institutional responsibility on the part of the state is quite weak for achieving ambient air quality standards. Only 33% of countries impose obligations on the state to meet legislatively mandated ambient air quality standards. Overall, there are other kinds of obligations, though, that are imposed on the state. A really important one, which I'll highlight, is the duty to plan, which is when an air quality standard is being breached, the government may then be under a duty to plan to its policies to try and achieve that standard. That has been a very powerful tool, particularly in EU law, for driving states to take action on air quality. There's an interesting phenomenon. We also, I saw that some countries seek to make individual operators primarily responsible for achieving ambient air quality standards, which conceptually is a bit of a mismatch because they're collective standards, but it's really about targeting high polluting sources and allowing for the enforcement of those standards against private individuals using the more routine machinery of a lot of environmental regulation. It doesn't address the collective and cumulative nature of air quality emissions that constitute air pollution. Sorry, I've skipped over a slide. That's, and there are some examples. My slides will be available afterwards, but you can also read the report where we go into all of this detail. Enforcing ambient air quality standards, and I know that certainly some members of the audience are really interested in this question. Enforcement measures for meeting ambient air quality standards are very complex to design. And again, it reflects the challenge of enforcing legal requirements that require policy coordination over a wide range of policy areas. And again, the state is the obvious candidate to be enforced against for ambient air quality standards, but they need to do a lot of work to meet them and also might be resistant to be subject to that kind of obligation. We see the most successful models of legal enforcement for ambient air quality standards happening in multi-level governance settings. You see that in the EU member states, particularly with the role of the EU Commission. And I put up an example from Australia, where there's an interesting kind of collaborative working arrangement between the Commonwealth and the states, where air quality standards are not being achieved. Direct enforcement action is rarer. And I want to highlight the case, which is very rare, and we didn't see many of these, of the decision of the Conseil d'Etat in France in July 2020, where it imposed a very heavy fine on the French government for failing to meet ambient air quality standards. And this was on the back of previous judgments by the court. It was quite a novel remedy by the court, a novel action, and it's a clean air campaigner's dream, that case, but it's a rarity. It's not what we were seeing a lot of, but an interesting development. And then there were other examples of more specific kinds of enforcement actions relating to a part of a regime or bringing it back to individuals again. And that's what the China and Jamaica examples are there. Two more points and then I will hand over to Delphine. One is, as I've made the point now a few times about air quality being a collective action problem, and there is a need to coordinate policy to achieve ambient air quality standards. And we saw some interesting examples of how that coordination is steered by legal architectures in our study. About a third of countries had some kind of mechanism for coordinating policy. It might be actually coordinating, mandating policy coordination. It might be requiring the legal coordination of air quality planning, or it might be something about decision-making for individual projects, linking that to ambient air quality standards. And then finally, I wanted to come back to this point about indoor air quality standards, which we really just scratched the surface on in the report. But we looked at whether there were in different countries generally applicable air quality standards that apply for indoor spaces, public or private, and we found very few. Now, we were not counted, as you can see, 7% of the countries we looked at. We didn't count ventilation requirements in buildings. That's not an air quality standard, even though it might help air quality in buildings, or occupational air quality standards, which we see a lot of very detailed air quality standards for certain occupations, depending on the exposures in those working environments. But this really shows the limits of existing regulatory approaches for ensuring that indoor air is safe. And as I mentioned at the start, they're the spaces where people spend most of their time all around the world. So there is room for development. I will now hand over to Delphine.
Thanks so much, Eloise. I'd now like to introduce Professor Delphine Misonne, who is going to speak on the subject of international law and the picture for air quality. Delphine Misonne is a Belgian Fund for Scientific Research Associate, Professor of Environmental Law and Head of the Environmental Law Center at the Université Saint-Louis Bruxelles. Professor Misonne is a leading scholar on climate change governance and ambient air quality issues, and is co-author with Professor Scotford of the UNEP report. Delphine, over to you. Thank you very much.
Yeah, thank you very much, Isra. Thank you, Eloise. What is it all about? Actually, it's about the air we breathe. We wanted to know how it is legally protected in the world. And as Eloise already said, the picture is one of complexity, heterogeneity. You can find all our sources in the attachment to the report by clicking on the links. Then you will have all air quality standards in the world has been organized by legal regimes, but it's very divergent, very different, and it's a bit weird because actually air pollution is not a new problem. It's a very old environmental issue, and it's interesting to see that you can actually see the trace of former model statutes like the US one, the Soviet one, and the EU one. But it's very clear. We see the impact of no multilateral treaty on ambient air quality protection today. There is nothing globally being proposed by public international law on air quality standards. That's maybe explainable, but it's a bit weird in a time of climate change. And also no global approach means no forum for global discussion. While we could feel through the study that there is a need for more interaction, more capacity, both on national regime and also on the issue of transboundary air pollution. By contrast, of course, we all know that there is something filling the gap. It's the WHO guidelines, and there are, of course, what we would say soft governance instruments. They focus on numerical issue, but what is very important with them is that actually they speak to people in the world, public authorities, activists, scientists, because they are quite clear actually, and they are also focused on health protection, which is not necessarily the case of all national regimes today. So the overall picture is a bit an uneasy feeling, uneven protection, while we are all humans breathing the air and having the same kind of requisites. For instance, in our study, we could actually highlight the fact that in legal regimes across the world at national level, 63% of them do not have any mention of the transboundary issue, while we all know that actually air pollution circulates across borders, and even ambient air pollution. What I focus here is on two aspects of our kind of model the monitoring issue and the procedural rights issue. But before that, I want to highlight another point is the, for instance, the presence of the zoning dimension in a legal regime. There are many zones being proposed in existing legal regime, but actually the meaning of the zone can be radically different and very different. Either they are proposed for assessment purposes, evaluation purposes, or on the contrary, for making a differentiation between what can be expected by people living in those areas. For instance, in some countries, you have fantastic air quality standards applying, but only in sensitive areas. And sensitive areas are natural parks, but nothing for people living in cities, for instance. Or you have a big difference still between industrial areas and cities areas, which can be a question, maybe in a modern frame about air quality regulation today. About monitoring, we see a lot of legislation, which, for instance, different aspects being covered, but not always being very precise on the monitoring dimension. While monitoring has started to be a legal issue, because, for instance, in Europe, in the EU, it has turned now to be a matter for judicial control. We all know between specialists that you can have a very different impact with air quality legislation, depending on the assessment you make of the air, ambient air. You can have a very nice picture of the quality of the air, or a very worrying picture, depending on how you measure, depending on which metric, etc., or where you place the measurement station. And it needs to be organized, but it's not always the case. You have many countries where it's not framed at all by the lawmaker, and then it's a difficulty. For instance, when you have a minister in charge of developing monitoring requirements at his own level, it does not really know actually how to do that sometimes. Procedural rights are part of the scope of our study. We all know it's very important in environmental law: access to information, access to justice, influence on decision making. And there we were nicely surprised, first by the advance of the global thinking and international law on the issue. You could really see the impact of Principle 10 of the Rio Declaration on many countries of the world, with, yes, quite a few aspects that are positive in that regard, but still we could find 40% of the countries in the world that do not make their air quality legislation available to the broad public. And that is really an issue today for lawyers, actually. But we have some positive news, like quite a lot of legislation actually include something on procedural dimension. And so you can read the data and results in the report. We could feel the rise of public interest litigation in the world on all continents through our studies. You can find examples of those public interest case litigation aspects, also on procedural issues like in the making of a revision of an air quality law, questions are being asked about the stakeholders to involve. It's not considered to be okay anymore to only have the industry on board, for instance. We need to have scientists, maybe the public, and the lawmaker. What makes a right to clean air? That's actually the fundamental question we are asking behind our study. Of course, we can have formal answer in relation to what we can find in the constitutions or in the specificity of the text. But for us, it's important to express the fact that we think there is a move going on from old installed legislation that were focused on the regulation of pollution towards new modern legislation that are more focused on the governance of air quality. There is a fundamental change here in the mindset. And so our conclusions is about a proposal for a robust air quality governance system. We are convinced that, like all other authors wrote in papers that are quite famous, that it's time to harmonize standards in the world, but we think it's not enough. It's not only about harmonizing standards. It's also about fixing institutional responsibility, monitoring, being transparent, participatory, support implementation, define consequence for failure, so discuss bindingness and enforceability. But it's not easy to make that move if you do not have from above or from beneath some kind of pressure. And but the time is ripe for that. We have many countries being a process of revision, for instance, and we make also some recommendation in the report. But I think the time is up. Just want to say yes, the most important one is make sure legislation is publicly available, because actually it's all about empowerment, also about empowerment of the citizen in the world. And so I leave it to you, Ali, because we have a next speaker. But first, back to Isra. Thank you.
Thanks so much, Delphine. So our final speaker is Professor Alistair Ali Lewis, who's going to provide some reflections on the Regulating Air Quality report from the perspective of air quality science and policy. So Ali Lewis is Professor of Atmospheric Chemistry at the University of York and a Science Director at the National Centre for Atmospheric Science, as well as Chair of the DEFRA Air Quality Experts Group. Professor Lewis is an experimental scientist who has studied the composition of the atmosphere and the impacts of pollution in diverse environments, from polar regions to megacities, open oceans to tropical forests. Thank you very much, Ali. I'll pass over to you.
So thanks very much for that introduction. And I'd like to thank UNEP and UCL and the authors of the report to give me the sort of final word in these presentations. I was going to make some comments about some of the wider issues that are raised by the report on air quality standards, and some of the science that might inform air quality standards in the future, and where perhaps this fits into policy and decision making. But I wanted to start off on a really positive note, and that was that air quality standards really work, and they're imperfect, and it's easy to pick holes in them, and it's always easy to find reasons to criticize those standards, to potentially improve them. But they are effective. And I was slightly nervous about picking out an example of how effective they were, but I thought I'd stay close to home and perhaps use the example of controlling nitrogen dioxide across the UK and the European Union more widely. And it's really a response and an action and an improvement to air quality that only happened because of ambient air quality standards. And this is obviously an issue that's had a considerable amount of coverage. Certain motor manufacturers have been in the sort of the eye of the storm over this. But this is an example, I think, where despite having emissions standards on individual products, it was only the existence of air quality standards and the exceedance of those air quality standards that drove catalyzed action and catalyzed change. So I think we have to keep at the forefront of our mind that we have these for really good reasons. They are an incredibly powerful tool in focusing the mind, in getting action, and in holding emitters to account, even though they are often rather remote from the actual original emission source themselves. And so we see now in the UK, and the same is broadly seen across Europe, if we look across the huge number of monitoring stations that exist in across the European continent, you know, we now see the direction of travel for a pollutant like NO2 finally going in the right direction. And it was air quality standards that have done the heavy lifting here in pushing governments to actually institute change. So what will follow in some of the other slides sounds often like a criticism of air quality standards, and I certainly don't mean it to be that. We have to remember that they are really powerful tools for creating change. But one aspect of standards that I think it's sometimes easy to forget is that the existence of standards leads to the existence of a huge ecosystem of monitoring and verification. And monitoring and verification is something that we almost certainly wouldn't have if the standards didn't exist. Almost everything that we know about the trends in air pollution, almost everything we've ever discovered about the impacts of air pollution on health, the impacts of air pollution on ecosystems, has been derived from measurements. And when we trace it back, those measurements in large part only exist because of the existence of an air quality standard that required a verification step to test whether the standard had been met or not. So the standard themselves might look like they're simply a piece of sort of written statute that's filed away on a shelf, but they spin off this enormous world of measurement and verification that is the underpinning of a massive amount of science and a massive amount of innovation and a massive amount of discovery. And you know, those standards are measured in all sorts of diverse locations, from the very remote places that are often organized through the World Meteorological Organization, through to national monitoring networks, and through to monitoring that's done at the city level. But it's really worth bearing in mind that a lot of this simply wouldn't exist if those standards weren't in existence. So because this creates a whole bunch of questions around who does the policing here. We can create legal standards for ambient air quality, but we have to come up with some decisions or some answers for who is going to do the measuring against that standard. And actually, very frequently, it's often the same governments that are setting the standards are the ones who are broadly in charge of measuring progress against attaining those. It's also really crucial to determine where we're going to measure attainment of air quality standards. If you choose to put your monitoring station by the side of the road, attaining WHO standards is going to be a lot tougher than if you put your monitoring in background suburban locations or in the rural environment. It sounds like a detail, but where we measure air pollution is incredibly important. It has huge impacts on the attainment of standards and whether those standards are really relevant to the air that people are actually breathing. Now, measurements, and I'm an experimental scientist, cost a lot of money, and there are always questions asked around, do we really have to measure? Could we not model it? It would probably be cheaper. We could get an assessment of air pollution everywhere. I think the short answer to that is no, we can't. One of the great powers of air quality standards is that they are measured against physical property that is ultimately traceable back to a standard unit of measurement, whether that's measured in any country around the world. There is a degree of traceability to that. So modeling informs policy making, it informs science, but ultimately I think it is the measurements, the physical measurements of air pollution that will always fundamentally have to underpin the verification of the attainment or otherwise of air quality standards. And the existence of all this monitoring infrastructure and all this ecosystem of measurement that goes alongside allows us to answer this fourth bullet point around equivalence across nations. And the short answer is generally yes, data is equivalent across nations. And that's actually a subtle and powerful driver for change as well, because when one has a consistent monitoring and verification infrastructure to support standards, it allows us to compare across countries. It allows league tables to be constructed. It allows pressure to be placed on decision makers to take action because of comparisons against equivalent countries in other parts of the world. So there are a lot of consequences for the monitoring and verification that drive action that are not directly related to the standard, but are related to the data that is produced that supports that monitoring and verification. And we've certainly seen, an explosion in comparisons of data between regions, between countries, and so on. And that is often as powerful a lever politically in driving action as the standards themselves. So this just leads on to a point that I want to spend just a couple of minutes talking about, and that's to answer this question really around what should we regulate, and therefore what should we measure, and of course by extension what should we control. And this is a really tough one, and we have a real classic chicken and egg problem here, because we collect a certain amount of information on the atmosphere and we link that through epidemiological studies over decades to look for health outcomes, and that's what informs our health and economic impact assessments, which often drives the development of air quality standards, which leads to policies being introduced, which means we commission new monitoring. But we often go round and round in a circle where we follow measurements that have existed for long periods of time. We follow pollutants for which there is a long history of ambient data, for which epidemiologists can construct relationships between pollution and so on, and health economists can produce assessments and so on. And it's actually quite hard for different metrics to break into this cycle. We need to keep this in the back of our minds at all times, which is that how will new metrics or possibly better metrics for air quality standards ever break into this cycle that goes round and round? And what we're left with, and this is what the report shows really clearly, is that the overwhelming majority of places where there are air quality standards are typically linked to these three: particulate matter in one of two size fractions, typically nitrogen dioxide and ozone. And this isn't to question that these don't have really significant health effects, because they absolutely do. But a lot of these are metrics for measuring air quality. They're probably not ones that we would design today. They're probably not necessarily describing all of the harm that occurs from air pollution. And possibly the most problematic one is PM 2.5, which is enormously influential in health impacts. It's enormously influential in air quality standards. It's enormously influential in the media and the wider public discourse around air pollution. But I don't think there's a single experimental scientist out there that would ever invent PM 2.5 as a metric to use today. And so, we have to be aware that our standards may need to evolve, and it is entirely possible in the future that we will develop better metrics for those health effects, rather than those three that we have at the bottom of the slide that largely define the air quality standards that we have today. So we should really go into these standards with an open mind, that there may be more revisions required, and we may find metrics that look different to the ones that have persisted over perhaps the last 30 to 40 years. I've got one kind of technical slide on here, and that's this question of pass or fail. And legal standards for air quality appear really pretty clear cut. And often when they're expressed in terms of a limit value, we talk about either attaining the limit value, a pass, or exceeding the limit value and failing. And of course, this is one of their great strengths. They're really easy to understand. It's a very clear message. You either pass or you fail. And so on my sort of cartoon diagram, I have the world that we would like, which is data which can be compared against a limit value or a standard, which is nice and clear cut. We have measurements that exceed there's a failure, someone needs to be held to account, or there's a pass and we are compliant and those standards are being met. But increasingly what we see is we're getting more of the purple. We have some data in some parts of the world and for some pollutants where, yes, we can say that air quality standards are met or air quality standards aren't being met. But we're also increasingly faced with lots of data where simply we're not sure. There is real uncertainty in whether the data tells us that a location is passing or failing the relevant standard. And this is something that we don't often address, and it really depends on the pollutant. So for some pollutants like ozone, we know whether we have passed or failed with a very, very high level of precision. But for PM2.5, the pollutant that probably most people want to talk about, it's really pretty uncertain. And the uncertainty in whether we have passed or failed, whether we have met or not met a legal standard, increases as concentrations reduce. And so the new WHO guidelines that were referred to earlier create an enormous challenge in this regard for legal standards. The new WHO uncertainty of WHO guideline for PM2.5 of 5 micrograms per cubic meter, the measurement uncertainty is about 70%. So that means, although I might measure 5, it could be 3 or it could be 8. So this is going to be an enormous challenge for the future for those legal standards to still be relevant and to be applicable in the real world. So that's my kind of slight downside and slightly negative view. We're going to have to get to grips with this in the scientific and the regulatory communities about how we will define whether the legal standards have been met or not. But just finally, I wanted my last slide to be ending on an optimistic note, and that's that we are entering an era which is a once in a lifetime opportunity for air quality. And that's because of the global actions that are likely to be undertaken to reduce carbon emissions and in many, many countries to head towards a world of decarbonisation and net zero. And the reason this is a once in a lifetime opportunity is that net zero type actions and decarbonisation strategies, wherever they're undertaken, are overwhelmingly positive for air quality. So the final diagram I've got here is an overview assessment of how a single country's actions to deliver net zero for climate change may impact on air quality. And you can see that we have better air quality on the right-hand side of the arrow and poorer air quality on the left. And overwhelmingly, almost all of those actions that we may undertake for decarbonisation and climate mitigation are positive for air quality. So we're going into this period of climate mitigation with the opportunity to make huge gains in air quality. So my point here is, I guess, public expectation for cleaner air should be higher. We're going to spend trillions and trillions of dollars on decarbonisation across the world, and we should expect there to be very significant clean air co-benefits delivered with that. And we should make those co-benefits of climate mitigation really explicit. And I've not written it down here, but we should design in clean air as being an expected outcome from any intervention that we take. And adding in really robust air quality standards, demanding really challenging good air quality, is going to be central to locking in those benefits. It's going to ensure that net zero actions taken around the world are going to deliver optimal pollution levels for urban environments and rural environments as well. So it's really hard to predict the future. And I've got a cartoon prediction, which is from a forthcoming Royal Society report in the UK of where pollutants may go. And it's really hard to know what the absolute concentrations will be. But if we can deliver decarbonisation and climate mitigations in the right way, we should begin to see nitrogen dioxide and SO2 disappear essentially from the sort of language of air pollution. We should be able to be close to eliminate them. For PM2.5, we don't quite know what we can achieve. It's not obvious that everywhere in the world could achieve a WHO recommendation of 5 micrograms, but we should expect to see huge improvements in PM2.5 if we do net zero and decarbonisation well, which will leave us probably with ozone as the only pollutant that's going to be really challenging to reduce to very low levels because of its nonlinear formation. So there's a lot to think about on air quality standards. They have an awful lot of spin-off benefits in other areas around driving measurements, driving change. There will be challenges, I think, in the future in measuring progress against those standards because of uncertainty in measurement. But I think we should all be using those standards as a way of locking in enormous benefits that should derive from the global shift to decarbonisation. So I'll finish at that point. Thank you.
Thanks very much, Ali. And thank you to all of our speakers for their wonderful presentations and also for keeping so well to time. We're now moving on to the Q&A portion of the webinar. We have quite a few questions submitted already, but please do continue to submit your questions. We'll try to get through as many as possible, and please be assured that we'll pass all questions on to the panelists. But before we start, I'd just like to introduce Alan Meso of the United Nations Environment Programme, who is also joining us to help answer the questions. Alan Meso is an environmental lawyer at the United Nations Environment Programme and an advocate of the High Court of Kenya. Alan has been instrumental in UNEP's work on environmental crime, judicial education, environmental rule of law, and in the development and implementation of chemicals and waste law. Alan was a member of the team coordinating the drafting and review of the UNEP report on global air pollution legislation. So great to have you with us, Alan. Okay, so I'm going to take, just to clarify for participants, I may have combined some of your questions. So if it doesn't resemble exactly what you submitted, please forgive me. So perhaps we can start with a question for Eloise, but any other of our panelists, please feel free to chip in, which is, how can governments and willful emitters be held legally accountable for the consequences of air pollution, including tens of thousands of deaths annually? And what can we do as individuals in this regard?
Thank you, Isra, and thank you for the question. So I'm going to deconstruct the question a little bit. So the question was, I think it was aimed at the UK government, but I think we can think about governments generally as well. I will start by talking about the UK position. How can the UK government be held legally accountable for thousands of deaths annually that are caused by air pollution? Well, the short answer is accountable for the deaths, i.e. for the people who've died of their families, then there is no clear legal route for that kind of accountability. We may get developments in human rights law and negligence law that might get us to that point, but we're not there yet. But certainly the UK government has been found to be legally accountable and should continue to be able to be held legally accountable for failing to meet legally required ambient air quality standards. Now, it has repeatedly been held to be in breach of those standards by various courts, and we've even had another judgment of the European Court earlier this year doing just that for the pre-EU exit in infractions. There is a really difficult question about how, if we ever get our new environment bill in England, whether the UK government will be held to account in quite the same way. That's going to depend on the powers of the new Office for Environmental Protection at the point that it comes into existence, assuming it does. And there's some real legal complexity there for meeting air quality standards, which we could talk about for quite some time. But it's not clear cut how that accountability mechanism will work in law, but there should be some form of legal accountability. What can individuals do is part of that question that you asked, Isra. I mean, Ali made the very good point that emission sources can be quite remote from air quality standards. And that's because air quality standards represent the accumulation of all different pollution sources. And individuals, it's the same for climate change, can in a sense feel a bit powerless in that context for what they can do to change the final outcome of what the state of the environment is. But nonetheless, it's the actions of all individuals, be in the industry or individual just citizens going around their daily life in cities and in rural environments, that the actions of all of those that are polluting add up to the levels of air pollution we have. So the actions of individuals do matter. You know, idling cars do matter. How industries are permitted does matter. All of that needs to be kind of brought together to try and achieve and that's where that's what policy is about trying to find the policies that make those individual changes and then add them all up to meeting the air quality standards. The other thing that individuals can do, which I might pass over to Delphine, is, and what we see, and Delphine made this point in her presentation, is there's a lot of public interest litigation, which is where individuals frustrated by the state of air self-organize, work through NGOs, and we've had, you know, some very effective NGOs to bring actions, legal actions against the government, against different governments, and that requires, again, a very, in different countries, those kind of actions will look different. They might be possible, they might be impossible, but require very close analysis of the legal architecture in that particular country and what kind of actions, legal actions, are possible.
Yes. If I may add something, air quality standards are often linked to planning requirement, and it makes them a bit special because you have a standard and it's for the public authority to plan and organize the link to sources and pollution control. And for long in the EU, for instance, European Union, it was just seen as a task for public authorities, and it's something falling into the margin of appreciation of the public authority, till we had a case before the European Court of Justice where actually we got a very interesting answer. It's not only a matter for the public authority, it's also about subjective rights of citizens, because we have air quality standards in law, in legislation, and the impact of that is that everybody must be able to claim its rights, or also to be aware of its obligations. And from that moment, actually, we could see a true exploration of what could the courts say, and different building blocks, like yes, plans can be requested by individuals, or individuals, like in the UK, can contest the adequacy of air quality plans, or where you put the measurement station, it's not enough, and the judge says in the EU, yes, I can control, it's my task to control where measurement stations are set, and if it's in adequacy with EU law. So it's very interesting to see what you can have when you combine first a legislation and answers being provided through courts. Unfortunately, we need to go that way to have answers sometimes.
The question is that, or the framing of the discussion is around limits and not about thresholds. And so the example that that was given was that in UK planning guidelines, we can see some perverse outcomes where it becomes easier to add new pollution sources in places that are already clean. And so the question is whether our regulations should be structured around continuous improvement and how we might frame such an obligation in law. Sorry to interrupt.
Yes, thanks. Of course, you can frame that in law by requisites to maintain and improve air quality. That's what we already have in EU law. I don't want to only focus on EU law, but maintain and improve means that you cannot go below a pre-existing level, but it will depend, if we have the global picture, on what you mean by a zone, for instance. Is it a zone to, if you zone your country and you say it's a zone for assessing air quality, there is no consequence. But if it's a zone for polluting up to a higher level because it's, for instance, an industrial area, there it's a pity. Even if you are at the moment in the countryside, you can be scared by future developments. So it will really depend upon what you write in your legal regime.
Eloise, did you want to come in on that?
Yeah, I think it's such a good question, and it's absolutely right to be critical of the focus on limit value or concentration-based standards as the kind of the focus of the report in one sense. I mean, the rationale for that is we're starting from a position of having World Health Organization guideline values and thinking about how they're being made legally binding or not. So that was kind of part of the question that we were seeking to answer. But I do think it's, and Delphine and I have spoken a lot about this, and there is, and Ali has mentioned in his presentation as well, there's a real question to be asked about the best design of air quality standards, and they don't have to be limit values. I mean, concentration matters for exposure, but it doesn't tell us anything really about the exposure of people in the community necessarily. And the question is absolutely right that gaming around limit values, because they are this, I mean, it can be both a good thing, they look like things that are easy to comply with, which Ali has told us is not necessarily the case, but they also do, they are ripe for gaming, and that increased pollution can happen in areas that are not yet that polluted, to compensate for maybe removing pollution from other areas, or just increasing urbanization or industry. Now, I think Delphine has offered one very good solution. I think there is a need to have a debate about different kinds of standards within an air quality kind of governance system. And I think that is a really important part of the discussion.
Thank you. Perhaps we can take a question from a slightly different direction. And this is one of the questions that was pre-submitted, which is, how do you see legislation on issues of air quality developing or progressing in low and middle income countries? So perhaps Delphine or Alan might like to speak to this question.
Thanks, so I don't know whether Delphine would want me to go first or...
No, please go, Alan.
Okay. Now, for me, I would look at the question from the perspective of both a concern and perhaps from the point of view that, yes, there's some light at the end of the tunnel. Concern in the sense of taking Africa, for instance, the number of countries that have legislative instruments containing these ambient air quality standards is quite low. So for me, that would be a concern. If you take, say 17 countries out of 55, then we're talking about 30% of countries in Africa that have a legislative instrument with ambient air quality standards. But then at the same time, I would look at it from the point of view that in Africa, in the same continent, they also have some regional framework agreements on air pollution. Now, perhaps it's about time to take advantage and reactivate these regional framework agreements as a platform for then developing and catalyzing action on air pollution. But not just that, we have now within UNEP, so to speak, a framework that has identified pollution, including air pollution, as one of the priority areas insofar as environmental law is concerned. We have a program that we call the Montevideo program on the development and periodic review of environmental law, a 10-year intergovernmental program that focuses on the development and implementation of environmental law. So this global mechanism, again, having identified pollution, and so in this case, I'm talking about air pollution, then gives us that opportunity to take that as a low-hanging fruit and catalyze action so that we can develop stronger frameworks on air quality. So yes, it is a concern, and especially in Africa, where only few countries have a legislative framework with ambient air quality standards, but then we have real opportunity or low-hanging fruits to actually catalyze action and support countries to develop these frameworks.
Thank you, Alan. Delphine, would you like to add anything?
Yeah. The question is, of course, very important because we see that uneven landscape about the state of legislation in the world. Do we have legislation on air quality standards, and what kind of detail do we have in that in the world? How to move forward or move differently? Yes, it will depend upon possibility of cooperation, I suppose, or as I said, yes, either from above an international framework or the link with the climate change framework, or from beneath, from the people. But then it will depend upon the possibility for citizens to go to courts, because we speak about legal issues here, and that's not easy in every country of the world, because it's also the fruit of an evolution to have access to justice in question like air quality. So it needs actually yes, different pieces of a big puzzle must move together. And we are not there yet. That's a bit worrying, because if I can speak as an academic, and I am here, of course, as a researcher and academic, I'm worried by the uneven playing field. It's like a distortion of competition, what we have on air quality standards being so different across the world, especially because we speak also about behind sulfur, we have coal, behind NO2, we have cars. So it's a worrying situation. And when Professor Lewis said that air quality could be the co-beneficiary of zero net and that new zero paradigm, I wonder if air quality standards and law could not push actually be the triggering factor for more improvement also on the other issues like carbon and better agriculture, etc.
Thanks very much, Delphine and Alan. I think we have a question that fits quite nicely, and I want to come to Ali in the first instance on this. And the question, which I think you spoke to at the end of your presentation, is whether action on air quality standards is falling down the agenda because of the attention given to climate change.
I mean, it's a good question. I mean, I think it's variable. I think it depends where you are and in what sort of context you're having the discussion. I mean, I think it's absolutely true that we went through a period, perhaps 20 years ago, where air pollution had really disappeared off the radar as climate change issues emerged. I think that there has been a certain amount of rebalancing, and because what we don't want is it to be a competition between the two. I mean, they're very, very closely linked to one another. I think we're now probably reaching a more sort of sensible position, which is the two are considered as being two sides of the same coin. But I think there is this issue around discussion and debate of the issues, which has to reflect that air quality is very much a local issue. It's very, very prominent in local politics, in mayoral elections, in regional issues, because it affects people individually, directly, and in the short term. So we shouldn't be surprised to see it being an issue with that kind of constituency. Climate change is a very different beast. It's global in scale, it's multi-decadal. It is kind of the business of governments and multinationals to take the lead. It speaks in their sort of language of strategy and multi-year planning and so on. So I think these two things have to coexist with one another. And I think we do see now that there is a lot of local engagement in air quality issues, which are a very powerful driver of climate change action. But I think if people are motivated locally by air quality, then that's great. Get on and use that as your motivation for change. If it's easier for large businesses and governments to frame the discussion around climate, well, then you go and do that if that works better for you. But I think the main thing is that we're linking much more in our discussions that the two aspects are really tied to the same decision making.
Eloise, do you want to come in?
Yeah, can I just add to that? I think I agree with that. It's a really good question. I think for the reasons Ali's just articulated about the different kind of constituencies that are kind of brought into the discussions, there's a risk still of there being different levels of government that engage with those issues and that don't necessarily join them up. And again, it's different, it works differently in different countries. But if central governments, and you see this in unitary countries, or maybe the federal level of government is very consumed with climate change policy, and local governments are more consumed with air quality control, there is a risk that those levels of government compete with each other for resources, and that the air quality challenge, which is collective and does need joining up still, falls out of the central government or the unitary government or the federal government discussion. And I think that's still a problem, and requires, and it comes back to what we're looking at in the report, to good overall governance for air quality, that the institutional structures are embedded for air quality standards to be at the heart of the part of government that's going to join up the policies that in the end achieve the standards. And the same thing has to happen for climate change. And as Ali's saying, that the discussion needs to be joined, but there is a risk that in some countries, it's different parts of government having the conversations and not necessarily talking to each other.
Thank you. I think we have time for at least one last question. So I'm going to select one that's been submitted just towards the end of the chat, which is, will the new human right to a clean and healthy, sustainable environment affect national legal architectures on air quality or the success of public claims in any significant way? So I'd like to open this up to any of our panelists who'd like to respond.
Patricia, would you like to answer that? Oh, no, you don't have to.
I think having a human right to a clean and healthy, sustainable environment does provide a very important context for ambient air quality standards. So given that many countries do have this right in their constitutions, having it now recognized at the international level gives, if you like, wind to the sails of getting actions that are catalyzed by, at the international level, it's really seeing that this is now acceptable here. So at the national level, can we have more enforcement and compliance mechanisms? And this is going to influence different areas. And I don't see how the question of air pollution is going to get out of that net. And basically the claims, anytime you have a recognition of a right at an international level, there is a certain political gravitas that comes with that recognition. That countries don't want to look bad. So it may actually, first of all, from the demand side, make people demand more, but also from the supply side, have governments feel under some kind of pressure to deliver.
Thank you, Patricia. Eloise?
I think I'll let Delphine go and I'll talk after her.
Sure. You're muted, Delphine.
Thank you. It's a very important development indeed. It will change the way to look at pollution. Actually, pollution is not normal anymore. It affects the rights of individuals. And even if we have it already in many national constitutions, that right to a healthy environment, it's still often indirect or submitted to the action of the lawmaker or governments. And so now it's a more direct proposition. Subjective approach. So I think it's a very important development, including on air quality.
I just had 2 points. One is in the context of our report, as I mentioned, we did look at when countries had constitutions that had rights in some way relating to clean air, that had whether they, we didn't look at how those rights are then developed within the legal reasoning of the courts of all those countries. But we certainly saw a correlation between countries that had those kind of rights and having a more developed air quality law system. And I imagine that countries that have systems of constitutional rights will be more open and to this international law development having some impact domestically. But my second point is living in a jurisdiction and working in a jurisdiction that does not have constitutional rights and is very wary of any kind of human rights in its jurisprudence that is not directly in domestic legislation, that in the short term, it will be very difficult for that development to have any impact on UK law. I think there will be, but as Patricia says, it will animate political discussion. It will probably put pressure on the government to do something about that. And it will be part of the debate. I remain a little bit skeptical about whether we will get a right to clean air in UK law anytime soon, but I think the campaigning will be bolstered by that development. I don't know, Ali, if you want to, any thoughts on rights? Isra, I think that's us. Yeah.
Okay, I'm afraid that we're getting close to the time, so I don't think there will be sufficient time to take a final question. So I think I will exercise the chair's privilege and draw the meeting to a close. I would just like to extend my sincere thanks to all of our panelists, our speakers today. So Eloise Scotford, Ali Lewis, Delphine Misonne, Alan Messo, and Patricia Kameri Mbote. Thank you so much for your time and your thoughts and contributions. And I'd also like to thank all of our participants around the world. And thank you so much for your attendance and also for your really excellent and stimulating questions. So be well, and let's all hope for some clean air. Take care. Bye-bye.
Thanks. Bye.